a quorum.
This meeting is being recorded.
I'll repeat. Good evening, everyone. We now have a quorum of members of the Zoning Board of Appeals of the Town of Orleans, and I'm calling the meeting to order. This is a regular meeting, February 2, 2022. Present are myself, Michael P. Marnick, Chair, members Lynn Eckholt, Gerald Mulligan, Matthew Cole, Emily Van Giesen, and Bruce Taub at present. Also present is Thomas Evers, the building commissioner of the Town of Orleans. We have 2 items on the agenda and we shall take them in the following order. Case number 2168 and then case 2163. Case number 2168 is the application of Christina Spade Rettler and Luke Rettler for a special permit in accordance with General Laws, Chapter 48, Section 6, Bylaw Section 164-21A, Note 5. That is building coverage exceeding 4,000 square feet. Now, the applicants are proposing to demolish the existing residence and construct a new home with an attached guest house on the combined lots, the total building coverage of 4,232 square feet. Now, this property is located at numbers 29 and 35 Uncle Mark's Way, which happens to be Orleans map number 12, parcels number 82 and 83. Has any member of the board had any communication with the applicant or any of the applicant's agents, which ought to be disclosed to the board or the public, or which would otherwise constitute a conflict of interest? Then I hear no positive response. Therefore, the members of the board are indifferent. I'm designating myself, Ms. Eckholt, Ms. Van Giesen, Mr. Mulligan, and Mr. Wall to consider this. All members of the board may inquire, however. Representing the applicant, I believe, is Mr. Zenda.
Mr. Marnick,
Yes.
may I proceed?
Yes, please.
Okay, well, first of all, good evening, everybody. It's nice to see you all again on the screen. My name is Ben Zender, and I'm here in Orleans on behalf of Christina Spade Rettler and Luke Rettler, who are the owners of the properties. With me on the screen, and you can see our Aaron Polhemus, who is the design builder, his representative Steve Glasheen, as well as David Little, who's done the site plan that you have as a part of your application package. This application is a type of application that the board sees on a fairly regular basis. Your bylaw, in addition to the 15% building coverage maximum in the residential district, also has a footnote in the bylaw that requires that where the building coverage exceeds 4,000 square feet, a special permit from this board is required. And so what we've presented to the board in our materials is a very well prepared site plan stamped by David Little that the member should have. I hope you have access to it. I can put it up on the screen if you need to see it, in which Christina and Luke are proposing to actually combine 2 of their lots into a single lot for building purposes. And we have prepared, or David has prepared, an approval not required plan to present for endorsement to the planning board to combine the 2 lots, but we're not going to do that unless and until we have the necessary zoning relief for constructing on the combined lots. So I'm presenting this application as if these lots were combined into a single parcel. And for the board's information, Christina and Luke also own 2 other parcels of land that are not buildable, that are closer to the water, that we are not using as a part of the calculations that I'm presenting to the board, for the simple reason that those are not upland parcels that would not be useful for determining building coverage, which under your bylaw is a function of buildable upland. So the two lots together, one lot has 43,474 square feet of upland. That's the lot 35 that's closer to the water. And then 29 Uncle Markwood has 37,670 square feet of upland for a total of 81,144 square feet of upland. Because the lot has over 80,000 square feet of upland, the applicants are permitted to right under the bylaw to have, two dwellings or a combination of two dwellings or guest houses. And so the proposal here is actually an attached dwelling plus guest house, which is compliant under the use tables. And we have also presented, as prepared by Paul Mr. Savory, a set of both floor plans and elevations that I think very accurately depict both the layouts of the first and second floor and basement of the main dwelling, the floor plan layout of the attached guest house, as well as the elevations of both the dwelling and guest house. The total building coverage and David has done a calculation on his site plan, is 4,519 square feet of building coverage, which is just over the by right amount. That's at 5.6% of lot coverage. That's if we don't count the soffits, that are extending from the sides of the building as part of the calculation. If we include the soffits in that calculation, then that number becomes 5,813 square feet, which would jump to 7.2. Well, not jump, but it would increase to 7.2% of lot coverage. The board can form its own impression of the attractiveness of the design. I like it. However, we have submitted a package of materials prepared by Steve Glasheen, which does an inventory of the nearby homes in the area, including a spreadsheet. And you should have those as part of your package as well. And in looking at that spreadsheet, the average building coverage percentage in the area is 6.74%, which falls between that, our numbers. And this is again a fairly large lot at 81,000 square feet. It's actually it's only exceeded by two lots in our calculation in terms of its size of buildable upland. So if the chair wants, I'm happy to read through the special permit granting criteria of 16444. I'm hopeful that you will waive that requirement, but I'm happy to go through that if the board wants. And with that being said, Aaron and Steve and David and I are here to answer any questions that you have. And we hope you see fit to approve the permit. And thank you.
Rather than addressing yourself to the criteria one by one, could I hear the questions from the board of the applicant?
I have no questions.
I have none.
I just have a question for my own information, not really pertinent, but would soffits be covered within the definition of covered landscape? Would soffits be included in that coverage ratio?
Mr. Chair.
Yeah.
Yes.
Through the chair, ultimately it's Mr. Evers' determination under the bylaw. The way that I approach the problem, I've always believed that, if overhangs cover usable area, for example, decks, walkways, structures, things like that, they would be counted. But then if they're just covering drip lines and things like that, they wouldn't. But ultimately, that's up to the building inspector to make that determination.
Mr. Chairman, yeah, we've always considered if they're decorative, no, we do not count them. If they're constructed in a way to supply to cover something, even to like store boats under or something like that, we do count them.
And these would be classified as decorative, would they?
In my opinion, yes.
Right. Thank you.
Well, in any event, you've given us the figures with and without.
Right.
I have
Yeah,
a
there's
question
actually-
that probably, go ahead.
There's actually 3 figures total. So when we get to that point, we should make sure to pin down the right number. There's 1 square footage in the advertisement that's lower than the two square footages in discussion currently. So What was advertised was 4,232 square
Right.
feet.
That,
So whatever
that was
we-
going to be
whatever-
one of my questions.
Thanks, Lynn.
Mr. Zender, it's
That's an
really,
error. That's actually an error in the initial, the problem looking back is I think we had drafted the application in advance of getting the final figures. We didn't correct that number. So I think for the purposes of making findings of fact, the board should use the figures that Mr. Little has shown on the site plan.
which is 4,513 square feet,
4519. Yes, Mr. Mark.
519. Ms. Eckholz, do you have a further question?
I have another question that I don't think is relevant to the issue of approving or not, but it's from my information, and Michael or Matt, you may know the answer. There's a plan for a Title V septic. And it makes the comment that there are services, Orleans Water Services. And I listened to a presentation by someone about water quality on Cape Cod, who said the biggest issue is having wastewater treatment and not Title V septic. And so my question, and again, this is informational for me, I don't think it pertains to approving or not, is when does the Orleans wastewater treatment go into effect? And is there a requirement to use it as opposed to Title V when it does?
Mr. Chairman.
Well, Mr. Zender, I was going to opine. but
Thank
maybe I'd
you.
like to hear.
Thank you, Mr. Marnick.
There's probably 5 or 6 people at this meeting that answer Lynn's question. But-
I thought there's somebody that could.
Mr. Zender,
Mr. Chairman, I was gonna say, I have no idea what the answer to that question is. I don't know what the timetable is for sewer connections in this neighborhood, and I don't even know whether the town is going to require hookup, for Title V compliant systems versus non-Title V compliant. I just don't know.
Lynn, the way I understand it is once the big pipe is available, then you hook up to it. Not in this neighborhood yet, but that's the way I understood it. So
When will
downtown, if the infrastructure is there, then you're required to use it. Otherwise, it would defeat the purpose of you never really fully accomplish what the clean water that you want and to prevent the migration of the chemicals into the water table. I think that's probably an obtuse response, but what I've eventually heard recently is that the only way to remove the migration of phosphorus is by a sewer system.
Right.
No
So,
alternative measure or Title V just doesn't do it sufficiently.
so do we know the rough timeline for when the possibility of new buildings in Orleans to be on the wastewater treatment will be, or do we not?
No, we don't, because we don't know what the town will do with remaining districts. We know that we've gone all the way down to Meeting House Pond pretty much. But after that, it's as much a financial and political issue as anything else. And probably the biggest hot button in town, I think, frankly.
Oh.
Maybe that's not germane to this application, but that's
No,
the way it is.
I
and
figured
think
it was
that-
not. I just wanted to understand it.
And we know we still get the flurry of that with certain applications which deal with the central business district. And now we'll see it further down Main Street. Do we have any other questions? Now, is there anyone else wishing to speak in favor of this application? I took the opportunity to see the participants at the meeting, and not shown by picture here is our board secretary, Stacy Faber. I needed, is there anyone, Ms. Faber, is the way I understand it, there has been no correspondence either in favor of this application or opposing it received by the file at Town Hall?
That's correct.
Very well. Now, is there anyone wishing to speak in opposition to this application? There is no positive response. Do you have any further remarks, Mr. Zender?
Mr. Chairman, I do
Yes.
not.
Very well.
Mr. Chairman, I just wanted to make a note that with these properties, I'm thoroughly familiar with them. I think it would make sense to have the properties combined and the setup as it's been presented. It's kind of a unique layout there with the land, and I'm in favor of the project.
Very well. I'll close the hearing for the taking of evidence. Ms. Van Giesen, would you like to move the approval then?
Yes.
Very well. Is there a second?
Second,
Second by Mr. Mulligan. Any discussion on the motion? There's no discussion. And Ms. Faber, will you poll the members designated to hear this? Myself, yes.
Okay, Ms. Eichholt,
Yes.
Ms. Van Giesen,
Yes.
Mr. Mulligan,
yes,
and Mr. Waugh.
Yes,
Thank you, Ms. Faber. The motion carries unanimously. I will write the opinion. Mr. Zender, would you provide a electronic version of some of the supports or a draft decision, whichever you're able to do as soon as possible?
Mr. Chairman,
Yes,
I'm happy to provide the chair with a draft decision for review.
very well. Through Ms. Faber would be great.
Thank you. And thank you all.
thank you.
Members of the board, now we consider an appeal from the decision of the building commissioner as zoning administrator. This is case number 2163. The appealing party is Scott Bean. The property is located at 94 Main Street, Orleans, map number 34, parcel number 28. The applicant refers to a letter dated November 3rd, 2021 from the building commissioner, which is included with the file for tonight's hearing, which makes a certain determination or determinations concerning the use of a boat slash sign at the premises. I will designate the following as 5. I don't know why we'll consider 5 members of the zoning board to consider this, being myself, Ms. Eckholt, Mr. Cole, Ms. Van Giesen, and Mr. Todd. Has any member of the board, including the members who will decide this, been in communication with the applicant or any of the applicant's agents concerning this hearing? No positive response. Does any member of the board have what might be considered to be a conflict of interest that ought to be disclosed to the colleagues on the board or the public or the applicant for that matter? No positive response, therefore,
Mr. Chairman, may I inquire?
yes, Mr. Todd.
Greetings, my apologies for not appearing on screen. It just guarantees I have a stronger connection. I don't 100% know how to phrase this, but if someone had an interest in real estate as their business, could that ever represent a conflict apropos to this particular issue? Perhaps even the issue we just decided.
I rule no, unless there's something further. Mr. Todd? Some other connection which would determine some bias, some extraordinary bias?
I accept the chair's ruling. Thank you.
Very well. And otherwise, Mr. Todd, you can do you state that you are otherwise indifferent and impartial?
I am impartial and indifferent.
Very well. Then may we hear from counsel for the applicant.
Thank you, Chairman Marnick. This is Anthony Ponabianco on behalf of Scott Feen, Atlantic Workshop, 94 Main Street in Orleans. We're here on what is now the third letter of a similar nature from Commissioner Evers related to the boat on the premises. And in this third attempt, it still has the same faults that are aligned with the other two letters that were sent by Commissioner Evers. Now, in this particular one, I'll note it states the November 3rd, 2021 letter, which you have before you. It states, I have determined that the boat showing your business name and logo is a sign as per 164-34B. 164-34B relates to parking spaces. It does not relate to signage. It does not relate to boats. It does not relate to home occupancy. So once again, though council was abreast of this and made aware of the faulty issues of the original prior zoning determination, again has a zoning determination which is incorrect. It simply cannot stand on its face. And that is one part of why we appeal from this particular determination. The determination cites to an absolutely inapplicable part of the bylaws. So it cannot withstand serious scrutiny here. The 164-34B relates to parking. Like I said, it does not relate to the signage edit and the boat at issue. Now, further that, we have already been through this particular issue of whether or not the boat itself is a sign. And the board voted on that to uphold that zoning determination. And they did not have, the board did not have sufficient votes to uphold that determination. So that has been determined already by this board. We're here now for a second time on the same question relative to the boat, which is unnecessary and should not be before the board in and of itself, but for the desire of the applicant to try to seek a remedy through the board and avoid unnecessary legal expenses in the Superior Court. As we noted in our prior communications relative to the first determination, which was not upheld by this board, so the appeal was successful. We noted that the boat in and of itself is permissible under the bylaws. Under section 164-35 of the bylaws, and a home occupancy employment is permitted one sign. they are permitted assigned, even if they consider this boat, which we do not to be assigned, it's permitted as of right. Now take that to the side. We believe that the boat, as we've said consistently, is not assigned. The boat in and of itself, as required under the bylaws, is required to have the name of the owner of the boat on the boat, which he did. They named the boat after the owner of the boat, which is Atlantic Workshop. The town does not have any applicable rules over where a boat could be located. The boat was previously, as we mentioned, the boat was previously located up on chains up on a tree and against the property prior to this being moved down closer towards the sidewalk. And at no point in time was there any objections from the town or otherwise that the boat itself was against any rules, because it's not. You're allowed to have, under Orleans bylaws, a boat on your premises. And a boat has to have the name of the owner on it, the one that is unregistered, which is, this is not to be a registered boat. So it displays the name of Atlantic Workshop, which is the owner of the boat, and it's permissible in that way as well. There are other towns across the Cape Cod community that have specific bylaws and regulations as to where a boat can be stored, where it can be placed, etc. Orleans doesn't have one. So they're effectively permitted to place the boat wherever they like on their property, as is commonly understood, and it had been for years prior to this zoning determination, that it now can't be placed where it is. Simply, the letter in itself, the November 3rd, 2021 letter, is deficient on its face. It cites to an inapplicable bylaw to make its determination. In the quoting sentence, it is my determination that it quotes to an inapplicable bylaw. It simply cannot stand. The appeal must be granted here in this particular instance, and the boat can remain where it is. That is what we're asking for, and that is what is proper.
Mr. Benebianco, let me ask you whether or not there's any language in the zoning bylaw which provides a sign shall mean any device, including recognizable logos, pictographs, and objects of similar nature, which is used to identify or advertise a permitted use, service, or activity in the zone in which it is located.
In 16434, there is not.
Does it exist anywhere in the zoning bylaw? Doesn't it?
That's irrelevant. What's relevant is whether or not the
Just say-
determinant,
okay.
let me finish.
All right, but please proceed.
It's irrelevant. It's what the determination is based on. If his determination is based on chapter 1, section 16434 of the zoning bylaw, which it is on its face of the letter, that's what has to be applied in this particular instance. It's not whether or not I can read the entirety of the bylaws or I understand them. That's, again, you've had 3 opportunities to get this right and you haven't. That is not the fault of the applicant. That is the fault of the determination that was made that has already been successfully appealed.
So
It simply is not in the section that is quoted.
so you're saying that once the building inspector incorrectly cited to 164-34 B, then that being inappropriate or irrelevant, then the entire determination was invalid? Is that your position?
That is one of the positions that we
Very
take.
well.
If you
Okay.
have, let me finish, Mr. Martin. If you are cited for, if you're cited for manslaughter, yet the actual thing that you were committing was speeding, it would be determined upon its face that it is an invalid citation. It's simply because they named the wrong statute, the wrong section of the statute or the bylaw, it would not apply. It's the same existence here, which you've had 3 opportunities to do and correct, and it hasn't been done.
You made that point clear, but the point, let me ask you one last time, then therefore the specific contain the a letter from Mr. Evers specifically quoting the language of the zoning bylaw, upon which he relied, even though it was incorrectly cited, that doesn't count, can't do it, no good, fails completely. That's your position.
In part, that is our position, yes. It fails on its face for that reason alone. The other reasons we cited are other reasons why it would fail, even if you were to consider beyond that, which I don't think is appropriate, nor do I think that you're permitted to do.
Okay, now, what relevance does it have that that you've been before us before? Why aren't we just considering your appeal from this letter? None of the previous proceedings are important, are they?
I strongly disagree, Chairman Marnick. The prior decision is based on the same exact holding, if you will, that the determination that the boat is assigned, right? It's the same holding that was in the prior determination and this determination. The prior determination for which we appealed was successful, meaning that we appealed it to say that the boat isn't a sign, and that was successful because the board voted to uphold it and didn't have enough votes, so the appeal stood. The appeal stood. That is what happened. So you can't now secondarily say, well, your appeal the first time doesn't matter. Our vote on it doesn't matter. You have to live by what your decisions were the first time through. This is essentially trying to get a second bite, even if it's the third letter on this, of the same apple from the board or the town, which they cannot do.
Well, I'm accepting your argument for what it is, Mr. Panabianco, and not a direction to this board what we can and can't do tonight. Now, the boat, there's language on the boat is, you say the boat is registered in those two words.
Sorry, could you say that question again? I didn't quite catch it.
The registration of the boat is in what name?
So the boat, because of the nature of the boat, doesn't have to be registered. Town Code 159, Section 3 requires that any vessel that is not required to be titled or registered, such as the boat at issue, must display somewhere on the vessel the owner's name, which it is. So
And
we're up, pardon?
And it's on the broadside of the boat rather than on the transom.
Correct. There's no location in section 159.3 that requires where it is to be, that requires it to be named, have the name of the owner on the boat. Doesn't say where it can or cannot be.
And do you have any evidence that that boat, say in the past 4 years, has been in the water?
It has been, yes, but I don't have video evidence of it being in water. That's also, I don't know if that's a necessary component of what the bylaw requires. It's simply that a vessel that's not.
I asked, the question is whether the boat had been used as a boat.
It has been used as a boat. It wasn't created simply for this purpose, if that's what you're asking.
No, I'm just asking a simple question. The fact is, has the boat been in the water and used as a boat? We'll say in the past 3 years.
Mr. Marnick, this is Scott. How are you? The boat, I bought that boat and restored it to teach my children how to sail. And so they have been learning how to sail in that boat. So it has been in the water in the last 4 years, correct? I hope that helps.
Are there any questions of any other members of the board? Mr. Silver is, let's satisfy the members of the board and we'll come to you. Any members of the board wishing to ask questions of Mr. Panabianco?
Mr. Chair.
Mr. Cole.
So if I'm understanding correctly, the business whose name is displayed on the boat is the title owner, title holder of that boat. And I'm just wondering if there is a copy of that title that could be provided to the board.
That type of boat is not required to be titled or registered.
That's exactly what I thought you'd say. So, Mr. Chair, there's multiple references to the code in the letter that Mr. Evers provided. The code cited is off by 1 digit. So the entire letter, as I can tell, is defective by 1 single digit. So I would make a motion that we get past that point and get to the heart of the matter. I think it's very clear from the letter that the violation alleged related to the sign portion of the zoning code, which again is 164.35 in reference to section B. It was off by 1 digit.
Mr. Cole, were you asking for a ruling that we're going to proceed and overlook the incorrect citation in the letter?
Yes.
I think it's of no consequence whatsoever, right? That's my ruling. The text is repeated in the letter, and there's no question about what the building inspector meant making his ruling.
Mr. Chairman, there's also two previous hearings where the issue was joined. So in addition to the failing of 1 digit, the applicant absolutely knew what the issue was at hand. And I find his argument to be completely disingenuous.
I wasn't going to rule that way, but I agree with you. Generally, it's that nobody was mistaken by or confused, or there's no egregious error in the 7th line of Mr. Evers' letter, as far as I can see.
Respectfully, Mr. Mulligan, the prior determination and the appeal that was successful, first, I think you have to make a ruling on that, whether or not you're upholding your own ruling and your own decision from before. But secondly, to say that it's disingenuous, you've had multiple opportunities, the town has, with town council, to get this letter correct. And in the first go around, the reason for it not passing muster from your board and not having the strength to uphold the letter is because of the deficiencies in it. It's not that it was confusing, it's that you didn't have the proper authority cited in your own letter to make that zoning determination. It's the same problem that you have in this particular one. So if you're going to argue that it doesn't matter, then you're arguing against yourselves in the first appeal.
Any other questions? Mr. Cole?
I just ask that we have some order to the proceedings. Applicant needs to wait to be called on. Twice you've spoken out of turn. We have other board members to hear from, and then we need to get through public comment.
I've given some latitude rather than inhibit casting light rather than heat on this whole issue. Mr. Wall.
Yes, I just basically have to say two things. Number one, there's no question that what's in front is a boat. And also in my mind, there's absolutely no question that that's a sign. So I think we're playing a little bit of gamesmanship here. Somebody can call it something else. But the fact of the matter is we can look through town, you can look through the rest of the country, and basically what you see there is a sign. The sign is on the boat. So I think I'll use my words here and say, I'm sick and tired of playing games on this thing. Thank you.
Thank you, Mr. Wall. Any other questions from members of the board? Who else present at this meeting wishes to speak in favor of
Michael,
overruling?
I don't have a question, but I do have a comment. Could I make a comment?
Yes, please.
Yeah, that's pertinent. I was one of the two people that voted against going ahead with the penalty, I will call it, the last time. I was one of the two people that caused the motion to fail. The only reason I voted no is because there was no proper statute citation. And as I understood it, you had to have a proper citation in order, courts would find that it needed to be proper in order to make it stick, in my words. But what you're saying now is that it's very clear that there was an error in one numeral, and it's clear what we're citing that is at issue here. And so that was the only reason that I voted no. I did not vote no for any that I didn't think it was a sign. I agree with Mr. Waugh, it's a sign. So I just wanted to make that clear that there was no citation, as I understood it before, or reference to the appropriate zoning law, which seemed to me to be an important issue if it were appealed. So
Thank you, Ms. Eckholt. And I was soliciting anyone present at the meeting who wishes to speak in favor of determining that Mr. Evers ought to be overruled in this appeal. Let the record reflect that there is no response from anyone wishing to speak in supporting Mr. Feed's position. Let the record reflect that the board has been in receipt of a letter from Mr. Wilkinson, which was duly circulated to members of the board, the substance of which was that he was in opposition to the application as presented tonight. Ms. Faber, is there any other correspondence than that I haven't, other members of the board have not seen?
No, that's the only thing that we received.
Very well. Now, let me ask if anyone present at this meeting wishes to speak. Again, casting light rather than heat in opposition to this application.
David Lawler.
Mr. Lawler,
I'm an attorney practicing in Hyannis, and I represent Connie Ahlstrom. And she's a neighbor and a butter of the property. I listened to counsel's arguments, creative arguments, why his client should succeed in this case. And I want to point out a few matters. I initially wasn't going to talk about what I would reference as a Mayor Scrivener's error in the notice. And it's not a manslaughter case. This is a zoning case. Clearly, his client has actual notice, legal notice. There's an error. Counsel was aware of the error. He represented it. He pointed it out. Clearly, he knew exactly what was going on, and the statute was quoted. And I believe this board is appropriate, and it's what appears to be its determination that again is just a like someone referred to it as a red herring, but I would not disagree with that analysis or that comparison. Now, with respect to a sign and the boat, again, a very creative argument that the boat is called the works, is called named after the company or the name of it. It would almost be akin to saying, well, you know what? Assuming it was still owned by the original owners, but you know what? That big yellow sign that says McDonald's, that's not a sign. It's part of my building. I'm putting my name on it. I mean, please. This board is given the ability and the power to make decisions and to weigh evidence presented before it. And part of that power is the use of your own common sense. And from listening to the comments of the board members, clearly common sense prevails that this is a sign. Clearly, this applicant has thumbed his nose at the board and at authority throughout the process because he wanted a sign. He sought to have a home occupation. He appeared before the board, and there was a restriction. I'm sorry. Feedback. But I'll continue to talk. I don't know if it's a problem. So that restriction was allowed. He appealed it. They have not received any relief from the court on an interim basis, and clearly it should not be up. If the applicant has a right to appeal, but he doesn't have the right to maintain it without without an order of the court pending that appeal. And we believe that the precedent that would be set here, if the building commissioner was overturned on this very clear issue, would haunt this board for quite some time. And the mere fact that it's inappropriate. The decision that was made was appropriate. And we suggest that the board act accordingly. Thank you.
Thank you, Mr. Lawler. Is there any member of the board wishing to ask any questions of Mr. Lawler for Mr. and Mrs. Alstrom, who are also present, I might add?
Yes, they are.
Chairman Marnick, if I may respond to Attorney Lawler's.
I haven't given you the opportunity yet. I'm still looking for any other people wishing to speak in opposition to the application. Mr. Silver.
I'd just like to say for the record that I am in opposition to the application as well. I'm a neighbor across the street. I think that the point's been made that it's clearly a sign. I just want the record to also state that the lettering on the boat would be upside down if the boat was actually in the water. So that's an argument with holes in it. And my original question was, when the boat was used in the water, did it have that sign on it at the time? If that was the requirement for a non-registered boat, but I think we've already moved past that. I just wanted to state my opposition to it on the record. Thank you.
Thank you, Mr. Silver. Well, let me digress for a second. Let me ask whether there was any evidence, Mr. Panabianco, that while as Mr. Feen has told us directly tonight, the boat has been in the water in the past 4 years. Was it ever in the water with the lettering on it? Is there any evidence of that?
You can testify to that, but I believe that it has consistently been utilized for that. If you're looking for photographic
For a
evidence.
finding of fact here, and I can't make a finding of fact that's sensible based on that response, on Mr. Feen's response, that sometime in the past 4 years, the boat's been in the water teaching us that he's teaching his children how to sail.
I'm waiting for Mr.
Well, obviously, we're looking for a finding of fact, whether or not the boat's been used as a boat.
And again, Chairman Marnick, I'll speak on behalf of Mr. Feen, who stated this earlier. As the owner of the boat, he has testified that he has utilized that boat as a boat in the water to teach his children who are in the Orleans School District to teach them how to sail. So yes, it has been used as a boat and been in the water to teach his children. Now, if I can address Attorney Lawler's comments that he.
Well,
sorry, Chairman,
let me just
looked like he wanted to ask a question.
Mr. Silver has also spoken in opposition. He had a question about whether the boat was used as a boat. Is there anyone else present wishing to speak in opposition? And then we'll hear from you, Mr. Panabianco.
Thank you, Chairman.
And no one appears to prefer to add to Mr. Silver, Mr. Wilkinson's, or Mr. Lawler's remarks. Mr. Panabianco, do you have a rebuttal?
I do, and I'll be brief in it since I understand the board understands the positions here well. Even if the board considers the boat to be a sign, which we don't concede and we don't agree with, even if so, it is permissible without permit under the bylaws to have a sign for a customary or self-employed home occupation. Under 16435 D, they're permitted to do so. They're permitted to have one sign for a customary self-employed or home occupation in any zone for which a special permit or variance has been granted by the Board of Appeals. In this particular instance, even if you look at it under the auspices of the bylaws and it being a sign, which we don't agree with, a customary or self-employed home occupation such as Atlantic Workshop is entitled to have that as a sign. Now, there are a number of different manners in which they could have a sign there. And they're entitled to it under the bylaws to do so. So even if you're to consider that, which again, we don't agree to, it's allowed by right without a permit, without seeking relief from the board, without seeking the building commissioner's approval. It's allowed as of right. So in opposite to what Attorney Lawler's saying, there's no thumbing the nose at the board or at the town. He's doing what is permitted under the bylaws, permitted as of right under the bylaws to do, even if you consider it a sign, which we do not.
May I speak because it was addressing to my comments?
Yes, Mr. Lawler, please.
Thank you very much. This board issued a decision on dated December 6, 2017 that I'm reading. And in granting the relief, item number 5 specifically states there will be no signage on the property. That overrides because it was granted by the board and he sought relief. And that was a decision that was rendered by this board. And that is clearly, they came in and they requested relief. They obtained relief under the bylaw, and that was a restriction. Now that's being appealed. They have the right to do that, but it's not been ruled upon. And until such time that that is ruled upon, it should be enforced by this board. And I will say, I'm a little embarrassed, Mr. Silver, that was brilliant. How could it be a sign if it was intended to be read upside down? Are they sailing around the boat with mirrors? I mean, please, use your common sense. Thank you.
Yeah, and if I may respond to Attorney Lawler, if I may, section 159.3 of the town bylaws, not the zoning bylaws, of the town bylaws, only state, quote, that they must display somewhere on the vessel the owner's name. It has no direction or where it must go. It's simply that it's somewhere on the boat. And Attorney Lawler made an argument about the precedent setting that would take place should you approve this appeal. The precedent, if you fail to do so, would be that you're stating to the town of Orleans that you cannot have a boat on your property. That's what you're stating to the town of Orleans. You're also stating to the town of Orleans that the decisions by the board in not withstanding not upholding the original zoning determination can be wiped away. You're setting a precedent that your own votes don't matter. They do. You already had this decision, and the appeal that the zoning determination that the boat was assigned is inapplicable. It doesn't apply. You must uphold your own holdings from your prior hearing and do the same thing tonight.
Mr. Cole. I see.
So I couldn't agree more that prior votes matter. Prior votes included the special permit where we granted the home occupation and prohibited a sign. Did we lose Mr. Evers? Is he not on the call?
He is. He's still with us.
So my question is why the letter did not also refer to the sign on the building that's also in violation of the special permit?
That sign's no longer up.
Okay. And the applicant referred multiple times to 159.3. Could you read the entire last sentence of that paragraph for the board's benefit, please?
You mean out of the town code?
I'm sorry, I'm directing that to the applicant. Could you please read the last sentence of 159.3 in its entirety?
A vessel not required to be registered must display somewhere on the vessel the owner's name, address, and active phone number.
Okay. Is the address and phone number displayed somewhere on the boat?
I believe that it is on the inside.
Okay. And could the applicant describe how the boat went back and forth to the water when it was used for sailing in the last couple of years?
Has a trailer.
He has a very large truck, which you know, Mr. Cole.
Matt, you go by the house every day, so I know that you're looking for the signs. But that boat, just like you have a boat, my friend, that boat goes to the water on a trailer. And we put the sails on and we go right out of town cove. Happy to bring you out anytime you want that.
So I've never seen in the time that this has been going on since it's become an issue, that boat move from the lawn. So
But you've also said
I
that
don't
there's been a sign on the building, Matt, that hasn't been
I
there
don't
for over 2
believe
years.
I don't believe the boat's been used. I don't believe that the name and address or the address and phone number are on the. You'd have supplied a photo if it were.
You can come on over and check it out.
It's a sign, in my opinion. I'm happy to make the motion when ready.
Any further remarks from any member of the board?
Yes,
Very well, Mr. Cole, you have a motion?
Marnick.
Mr. Tom,
Thank you, sir. I hesitate to say this in public meeting, but in the interests of openness and transparency, I will go forward and say that this has smacked to me, and I regret this characterization, as a kind of popularity contest. People are angry at Mr. Feen for his arrogant attitude, for his attempt to pull things over on us, etc. But the fact is, one, that there was a mistake in the letter, and before we offer even more grounds for appeal, we should at least hold a vote saying that we accept the notion that it was a Scrivener's error, that should be in the record. And the next thing is just to note that it would be important that this ultimately go away as an issue that consumes us. And the best way to do that is not to leave any avenues for successful appeal. And I want to make sure before the vote that we have done that. I'm complete. Thank you, sir.
very well, Mr. Tom. Mr. Cole, do you have a motion?
Can I just say that I saw Miss Van Giesen's hand up?
Oh, I'm sorry. I wasn't looking correctly. Ms. Van Giesen?
Thank you. I just would like to ask Mr. Feen a question. Mr. Feen, could you just please remind the board and the public your purpose and your intent with having the boat as a sign out front?
So the town, I need to store it somewhere, Emily. And I have a young son that is very into sailing. I know that you can appreciate that. So I am looking to make sure that my children are able to get on the water, since we live in such a beautiful place. And I need a space to house that.
So this has no correlation with your business whatsoever.
It has the name of Atlantic Workshop on it. It can have any name, doesn't matter what orientation. And I've seen a lot more curious orientations in the Bahamas sailing. So didn't think it was that big a deal.
Overall, I think while we're looking at this situation, many of you would agree and have vocalized that there's a lot of game playing happening here. I strongly believe in supporting local business. You know, that's what keeps us running here. Based on the fact that this has just exploded into nonsense, really, and over intricacies that really just don't make sense. And on top of it, you know, we're here to support the community. We want our businesses to thrive. However, I just feel at this point, there is a lot of disrespect going on to the community in general. And so I just would like you to consider that in your position in what you're presenting to us and presenting to the community. And what you're asking, really.
I understand that, Emily, and I appreciate it. There, 4 years ago, the first night you were on the board, as a matter of fact, was your first vote for no for my business. And when I approached the board after meeting with the building commissioner and Tom prior to ever even purchasing this property, I laid out exactly what my intentions were for 94 Main Street, including the barn, including the workshop. And I was given every assurance that whether if I followed the letter of the law to the build, and I was appreciative of what the town had asked me to do, which we did all the way through it. And before I were to lay chisel to wood and make a piece of bespoke furniture or lighting for one of my customers, that I would stand in front of the ZBA and ask for permission to do so. When I got to that ZBA board meeting, the same question that Mr. Marnick asked tonight was brought forth. Does anyone have a reason that they should not be voting on this? And everyone said no. But the lady that brought you in, that you sat next to, immediately struck up and said that because she was a realtor and lived in a cul-de-sac in Orleans, she wasn't allowed to have a sign at her home. So she didn't believe that I should be able to have a sign at my business. Not only was that the first wave of this whole debacle, but to put on restrictions like review annually, no employees, not allowed to receive products so I can make things, not allowed to make retail sales on my property, not allowed to run my machines after 5 p.m. All of these things, this ZBA board has put a chokehold on my livelihood to support 2 small children and a wife here in Orleans. We spent a lot of money on this house and this property, as you all know, and we've only kept it to the highest standards. So as we would have something that the town could be proud of. And I was in Chatham for 8 years prior to coming to Orleans and making this home and making one final workshop, and had a business and a gallery on Main Street, had workshops throughout the town, and every single person there respected what we did. And all we had ever asked for was the signpost that's out there, that we were allowed the same permissions that everyone else in this town who has a home occupation, like our locksmith, like our violin repair person, and many, many others, including the woman who sells garlic seasonally, who I'm sure that all those signs are sanctioned all over up and down Tonsett Ave. All I'm asking is the same respect that those businesses are given to run my business. I'm not Christmas Tree Shop, I'm not Yak Arts yet, but I do have a clientele that needs to come and visit, and they need to know that there's a brand. Okay, so I need some way to be able to tell the folks of the world that, hey, Atlantic Workshop has a physical presence out there somewhere. That's all we're looking for.
With all due respect, Mr. Feen, it was your decision to purchase property in a residential area. It was your decision to try and change this zoning, which is why you're here in front of the board. And the board has repeatedly denied your request.
Emily, that's not
this
what
particular, excuse me, I'm still speaking. This particular space is in a residential area. The zoning board repeatedly has said no. You're a very smart businessman. You have an amazing talent for what you do. And this space is not the only space that a business can be run out of for your craft. So, you know, to me, it's hard to really understand your side of the argument, especially since you're in a residential area.
Emily, I'm sure they taught you at
No,
Sotheby's.
no. We're getting a bit far afield here, and accepting myself and your colleagues, Emily, appreciate your remarks in general on the entire application. We greatly appreciate it. But I'm not going to let this degenerate into a point and rebuttal with Mr. Fee. I'll give you one more chance, Mr. Bianco, because I think we're done here otherwise.
And just to respond to Ms. Van Geysen's statement that trying to change the bylaws here, that is absolutely untrue. We're trying to live to the standards of the bylaws, and at every step and turn, he has done so. If you consider it a boat, he has done so. If you consider it a sign under the bylaws themselves, a sign for customary or self-employment home occupation is approved as of right without a permit. Even if you consider it a sign, we were following the letter of your bylaws, not trying to change anything, trying to get you to uphold what your bylaws and the town bylaws say. That's it. Not trying to change them at all.
Very well. I'm closing this for a hearing for the what is now, rather than taking of evidence, it's turned into an argument. Is there a motion to dispose of this? Mr. Calder, were you prepared to make a motion before?
Yes, is there any further discussion from the board before I make a motion? I think we've heard from just about everyone.
I'm thinking that the discussion can occur after motions on the table.
So I will, I'm going to go ahead and make a motion that I will vote against. The applicant has asked for an appeal to overturn the building commissioner's decision. And I will make a motion to grant the applicant's appeal and overturn the building commissioner's decision.
Is there a second on that motion? There is not a second, Mr. Cole. I will make a motion then, therefore, to deny the appeal of Scott Fee from the determination of the building inspector by letter of November 3rd, 2021. Is there a second to that?
Second.
Any discussion on the motion? I wanted to make one remark that the wisdom of the town in determining where a sign can or cannot be begs the question to some extent, because rolling back to December 6th, 2017, we have a decision which, after a hearing, the condition, one of the conditions was that there was no signage on the property. And I have and will reaffirm my ruling that the reference to 164-34B was either a scrivener's error, but of no consequence to the decision of the building inspector. Any other discussion on the motion? Very well.
Michael?
Yes,
Yeah, I was just
Michael,
going to
please.
say, I'm just going to say that, again, I've not been involved. I was not involved in this case in 2017. So there's no, no annoyance or popularity contest here. As I said, there was no proper citation in the original letter from the building commissioner. And I'm relying on your judgment that it's a scrivener's error and inconsequential. The intent of the letter and its referencing was clear. So I would not agree with the appeal at this point because of that.
Very well. Any other discussion on the motion?
I love you, baby.
Mr. Taub's hand is up.
Oh, thank you, Mr. Todd. We have a black screen and a yellow hand.
Yes, that's me. It's my secret name is Yellow Hand. I travel with our indigenous brothers and sisters. I just again, in the spirit of that we represent community interests, if people will not like me for saying this, but if we liked this applicant, we wouldn't have given a damn. That's what I honestly believe. And this is, when you talk about this as a strict zoning issue, that's a somewhat unique location in town that has often been discussed and is followed right on the other side of it, heading toward the east with numerous signs. I have not researched the code as to what extent the zoning bylaw changed, but it clearly does. As you move toward the beach, the zoning bylaw changes and signage, et cetera, et cetera. If the community was genuinely welcoming of this man and his business, which I regret has not been the case, this would play out differently. And if we hadn't encountered as much arrogance, it might have turned out differently either. But I want to say in advance, as people know, I'm going to vote to not support the town building commissioner here. And I've stated that my reasons have to do with our subjective opinion as to what is most beneficial to the town when we rule on variances and other exemptions. And we've done so conscientiously here, but I don't agree with the result. Thank
Very
you for your
well.
time.
Very well. Ms. Tabor, will you want to hold the board on the motion is to affirm the, excuse me, the motion is to deny the application to, with the effect of which would be to invalidate Mr. Evers' determination of the, in his letter of November 3rd, 2021. I vote yes to deny the application.
Okay, Mr. Cole,
Yes.
Ms. Eichholt,
Yes.
Ms. Van Giesen,
Yes.
Mr. Taub.
No.
The
Vote.
motion carries 4-1. I will write the opinion. Thank you, colleagues.
Thank you all. We'll see you again soon.
Members of the board, there's no further business to come before the meeting, and I will entertain a motion to adjourn.
So moved, Mr. Marnick.
Thank you,
Second.
Mr. All in favor by acclamation? Aye.
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 Bye, Emily.
Good night, everyone. Thank you for all the input, whether you succeeded or did not succeed.
Thank you as always, Mr. Marnick, for your excellent chairmanship.
Oh, thank you, Mr. Tom. Good night.